Hello, everyone, and welcome. Today, we're going to be focusing on Chapter 19, which is examining law, society, and the mental health profession. So, as we've learned during our time together, that when we think about psychological dysfunction, this does not occur in isolation. It is influenced and sometimes caused by different social factors and societal based factors. It affects all of our lives. It affects not only the lives of our clients, but it affects you and me and the family members of the person who's impacted by a severe mental health issue, the community, the nation, and even the globe. When we look at how dysfunctioning occurs, scientists and practitioners don't always conduct their work in isolation. Typically, they are also incorporating other aspects of society, which may be based on things like if we're using behavior modification as an example, part of behavior modification may be to not utilize certain aspects of, for example, social media. It's also using other things like books for bibliotherapy or skill training by another practitioner to help with a skill deficit that our client may have. It may also be by encouraging our clients to do things like return to school, get additional training for their jobs, or the like. When we think about social institutions, there are two social institutions that have a particularly strong impact on the mental health profession. This is the legislative and judicial systems, which is often called the legal field. So when we think about this, there are essentially mental health professionals, psychologists, social workers, counselors, and psychologists even, we'll focus on those four. They often play a role in the criminal justice system because they have psychology in law. The legislative and judicial systems act upon the clinical field, which regulates certain aspects of mental health care. This is law in psychology. There's also a branch called forensic psychology, and this is looking at the intersection between the mental health field and the legal and judicial systems, and is growing in popularity. So when we look at psychology in the law, how do clinicians influence the criminal justice system? So in order to arrive at a punishment that is appropriate for a crime that has been committed, the courts need to know whether the defendant is responsible for committing the crime and capable of defending themselves in court. So people who suffer from certain severe mental health conditions or mental health instability may not be responsible for their actions at the time that this occurred, or they may not be able to defend themselves in court. And these determinations are guided by clinicians within the field, typically psychologists. We also have what's called criminal commitment. This is when people are accused of crimes they are judged to be mentally unstable for, and they're usually sent to a mental institution or some type of inpatient care for treatment. Those who are considered mentally unstable at the time of the crime, they may be found not guilty by reason of insanity, also known as NGRI. Those who are mentally unstable at the time of the crime are going to be committed to an inpatient facility until they are competent to stand trial. So as you can see, there are differences. Was the person guilty at the time of the crime, but not today? They'll go somewhere inpatient to receive treatment until they're able to be cleared by a clinician and then go to trial. Was this person competent at the time the crime was committed? If not, they may be found not guilty by reason of insanity, and they will be they will be committed to an inpatient facility until they can be released back into society in a healthy way. When we look at the judgments of mental instability, they have stirred many arguments because some people consider the judgments to be loopholes, and others argue that the legal system can't be just unless it allows for such extenuating circumstances like mental instability. When we think about criminal commitment, this differs from country to country, but for the purposes of this class, we're going to focus on the United States. So how do we even look at not reason or not guilty by reason of insanity? Well, first let's look at insanity, because this is a legal term. This is where the defendant may have a mental disorder but not qualify for a legal definition of insanity. And at first, became evident back in 1843 in the murder case of Daniel McNaughton in England, which created the McNaughton test. This test states that experiencing a mental disorder at the time of a crime did not by itself mean that the person was insane, because the defendant also had to be able to know right from wrong. If the person knew right from wrong, then they could still be charged with a crime. The McNaughton test was able to see, does the client or the defendant understand right from wrong? In the late 19th century, there were some courts that adopted different standards of insanity. So the two that were used, one was the irresistible impulse test, and this emphasized the inability to control one's actions, especially if someone was advocating for the defense of something occurring in the fit of passion. There was also a third test that had become briefly popular called the Durham test, and people weren't criminally responsible if their unlawful act was the product of a mental disease or defect. But this all changed in 1955 when the American Law Institute developed a test that combined the aspects of the McNaughton, irresistible impulse, and Durham tests. So this combined test held that people are not criminally responsible if, at the time of the crime, they had a mental disorder or defect that prevented them from knowing right or wrong, or from being able to control themselves and follow the law. So as the test was adopted, it was criticized for being too liberal, and people said that, you know, those who were advocating for the defendant could get the defendant to essentially say anything in order to be able to be released and then reoffend again. So in 1983, the American Psychiatric Association recommended a return to the McNaughton test. And again, with the McNaughton test, we note that this test essentially, that this test essentially, again, created in 1843, says that experiencing a mental disorder at the time of a crime did not by itself mean that the person was insane, and that the defendant also had to be unable to know right from wrong. So this test is now used in all cases tried in federal courts and half of state courts, including New Jersey. The more liberal American Law Institute standard is still used in the remaining state courts. The exceptions are that 4 states have eliminated insanity pleas altogether. So the 4 states that do not allow for insanity pleas are the states of Idaho, Kansas, Montana, and Utah. So under the McNaughton standard, about 2/3 of defendants are acquitted by reason of insanity, qualify for a diagnosis of schizophrenia. The vast majority have a history of past hospitalization, arrest, or both. About 50% of these individuals are Caucasian, 86% are male, and about 65% of cases involve violent crimes of some sort. Close to 15% of those acquitted are accused specifically of murder. What we see here is a review of the not guilty by reason of insanity verdicts in a number of states show that most people who are acquitted on this basis had been charged with violent crimes. And the violent crimes are seen here. I encourage you to take a look at figure 19.1 and continue on when you're ready. What concerns are raised by the insanity defense? Well, despite the changes in the insanity standard, there's still criticism of the not guilty by reason of insanity defense. One concern is the fundamental difference between the law and the science of human behavior. The law assumes that individuals have free will and are generally responsible for their actions, but the science of human behavior assumes that physical or psychological forces act to determine the individual's behavior. A second criticism points out the uncertainty of specific knowledge about abnormal behavior. There's still a lot that we don't know. The largest criticism is that the defense allows dangerous criminals to escape punishment. They'll serve their time inpatient and then they go right back on the street. And if they're placed on medication and they stop taking their medication, they are now at danger of reoffending or potentially harming society again. When we look at these concerns, and in looking at most of US history, there's been successful insanity plea amounts to a long-term prison sentence. But today, offenders are being released earlier as the result of the greater effectiveness of things like drug therapy or other treatments in institutions, the growing reaction against extended institutionalization, and a greater emphasis on patients' rights. But again, just note that there's still flaws in the system. Besides not guilty by reason of insanity, are there other verdicts? So, yes. So, one that has been added is called guilty but mentally ill. And this is where defendants who received this verdict are found mentally ill at the time of their crime, but their illness was not fully related to or responsible for the crime. There are some states that will allow for another defense called guilty with diminished capacity. Those who are found guilty with diminished capacity show that the defendant's mental dysfunction is viewed as an extenuating circumstance that should be considered, but is not solely responsible for it. We also need to talk for a second about sex offenders. So what are sex offender statutes? Well, these statutes first became passed in 1937 in Michigan, where they created a law called the Sex Psychopath Law. Since then, there are many states that have placed sex offenders in a special category. A lot of this that will fall under mentally disordered sex offenders. These are people who are found guilty of a crime and judged to be responsible, but who are committed to a mental health facility instead of prison. However, this is beginning to change and has changed over the past 2 decades, where most states have changed or abolished these laws. States are now less concerned about the rights and needs of sex offenders given the growing number of sex crimes that occur. Some have passed sexually violent predator laws that require prison plus involuntary treatment. We also need to look at criminal commitment and incompetence to stand trial. So, regardless of their state of mind at the time of a crime, defendants may be judged mentally incompetent to stand trial. And this requirement is meant to ensure that defendants understand the charges they're facing and can work with their lawyers to present an adequate defense. Some are not able to do that. So how can one zealously advocate for themselves or be advocated for on behalf of their lawyers and have the right to a fair trial if they don't understand the charges being presented to them and they can't help their lawyers? This standard of competence was specified by the US Supreme Court in 1960. So essentially what happens is that if the court decides that the defendant is incompetent, that person is assigned to a mental health facility until they are competent to stand trial. Many more cases of criminal commitment result from decisions of mental competence than from the verdicts of not guilty by reason of insanity. It should also be noted that most criminals who are currently institutionalized for psychological treatment are convicted inmates whose psychological problems have led prison officials to decide if they need treatment. And in the prison systems, there are social workers and psychologists as well as counselors, or a combination thereof. Until the early 1970s, most states required that mentally incompetent defendants must be committed to maximum security institutions, but under current law, they have greater flexibility, and some defendants are treated on an outpatient basis. We also need to talk for a second about race and forensic psychology. What you see are on the left-hand side column are racial and ethnic minority individuals. What you see on the right are non-Hispanic white individuals. And you can see that there are marked differences between those who are considered non-Hispanic white and those who are of minority status. I encourage you to pause for a moment to read this chart and continue on when you're ready. Figure 19.2 looks at a number of studies. And according to these, I think there were 10 studies or 8 studies, but according to these studies that were conducted in several Western countries, psychological disorders are much more prevalent in prison populations than in the general population. So for example, you can find the schizophrenia and personality disorders, particularly antisocial personality disorder, are each 4 times more common among prisoners than among civilians or non-prisoners. So how do the legislative and judicial systems influence mental health care? Well, just as clinical science and practice have influenced the legal system has also influenced criminal or clinical practice. The courts have developed the process of civil commitment, which allows certain people to be forced into mental health treatment. And the legal system, on behalf of the state, has taken on responsibility for protecting patients' rights during treatment. And this protection extends to patients who have been involuntarily committed, as well as those who have sought treatment voluntarily. Every year in the United States, there are large numbers of people with mental disorders who are involuntarily committed to treatment. Typically, they're committed to mental institutions, but some states also have some form of outpatient civil commitment. These laws have caused long controversy and debate because treatment, you have to be essentially prepared and ready for treatment. If you're being involuntarily committed, you may A, not get the treatment that you need, or B, get as much treatment as you can and essentially tell the therapist what it is that they want to hear so that they will release you and then go back to your ways or stop taking your medication. Generally, the U.S. legal system permits involuntary commitment of individuals who are considered to be in need of treatment and dangerous to themselves or others. So these are going to be considered those who are suicidal, those who are reckless, and those who put others at risk intentionally or even unintentionally. The state's authority typically rests on the duties to protect the interests of the individual and the society. So when you are looking at the principles of parens patriae, are patients of the country, you are essentially looking at how the government through the courts intervene on behalf of individuals or groups of individuals who are unable to represent their own interests. And you essentially want to make sure that you are protecting those who can't necessarily protect themselves. When you're looking at the principle of police power, you are essentially looking at the permissible scope of federal or state legislation and how it may affect the rights of an individual when those rights conflict with the promotion and maintenance of the health, safety, morals, and general welfare of the public. So this is where you are looking at the states to regulate behavior and enforce order within their territory so that the general welfare of those within that territory are protected. When we look at the civil commitment laws, they're going to vary from state to state. Family members can often begin the proceedings, and there are very few guidelines that have been offered by the Supreme Court. But the only thing that has been standard is the standard of proof requirement since 1979, that there must be clear and convincing proof of an illness and of meeting the state's criteria for commitment. And again, this varies from state to state. We talk about emergency commitment. Many states give clinicians the right to certify certain patients as needing temporary commitment and medication. And this requires the agreement typically of 2 physicians and or mental health professionals. And these certifications are referred to as 2 PCs or 2 physician certificates. The length of stay is often limited to 72 hours or 3 days and can be extended as needed by the institution. Typically what happens is that every institution or inpatient facility has their own legal team within their building. The person who oversees it is a magistrate or a judge or a lawyer who is trained in medical-based cases, who will hear all sides of the argument from the staff at the inpatient facility, as well as on behalf of the client or the client themselves, and then determines, does the person get released or does the person stay for another period of time? And that period of time can range from another 72 hours to 7 days to 10 days to even 30 days. And often it is going to be consistently reevaluated as the person is inpatient. So who is considered dangerous? Well, historically, people with mental illnesses were less likely than others to commit violent or dangerous acts because of mass hospitalization. But Since deinstitutionalization, it's no longer the case. Approximately 90% of people with mental disorders are in no way violent or dangerous, but studies now suggest at least a small relationship between certain severe mental disorders and violent behavior. When we think about who is considered dangerous, we have to go by what is observable behavior or reported behavior. So a judgment of dangerousness is often required for involuntary commitment. So what are the problems with civil commitment? Well, civil commitment has been criticized on several grounds. Number one, it's too difficult to assess who is considered dangerous and what is considered dangerous. Number two, the legal definition of mental illness and dangerousness are extremely vague and open to interpretation. And number three, civil commitment has questionable therapeutic value. So on the basis of these and other arguments, there are some clinicians that believe that involuntary commitment should be abolished. Others advocate for finding a more systematic way of evaluating dangerousness, including more specificity of what is considered dangerous. The flexibility of involuntary commitment laws peaked in 1962. That's when the Supreme Court ruled that imprisoning people who suffered from drug addictions might violate the Constitution's ban on cruel and unusual punishments. And as the public became more aware of these issues, states passed stricter standards for commitment. Today, we find that fewer people are institutionalized through civil commitment proceedings than in the past. But ultimately, we want to protect patients' rights. Over the last 20 years, court decisions and state and federal laws have greatly expanded the rights of patients with mental disorders, including the right to treatment and the right to refuse treatment. So how is the right to treatment protected? So when people are committed to mental institutions and don't receive treatment, the institutions became prisons for those who were not convicted. In the late 60s and 70s, there were large mental institutions that were just that, those who refused treatment but were not released. Some patients and their attorneys began to demand that the state honor their right to treatment. In 1972, there was a federal court rule that stated that the state was constitutionally obligated to provide, quote, adequate treatment to all people who had been committed involuntarily. In 1975, the Supreme Court ruled that institutions must review case files periodically and that the state cannot continue to institutionalize against an individual's will who are not dangerous and who can survive on their own or with help from responsible family members or friends. In 1986, Congress passed the Protection and Advocacy for Mentally Ill Individuals Act. And this set up protection and advocacy systems in every state and US territory in order to reduce the number of people who were institutionalized without treatment and against their will. There's a number of advocates who are now suing federal and state agencies demanding that they fulfill the promises of the community mental health movement in which they started and have failed to follow their obligation to. So over the past 20 years, the courts have decided that patients, particularly those in institutions, do have the right to refuse treatment. Most rulings center on biological treatments, including psychoneurosurgery. But some states have acknowledged a patient's right to refuse things like ECT or psychotropic medications, as there are harmful side effects. And the state or I should say, as they've become aware of these side effects, has granted the permission to refuse treatment. So what other rights do patients have? Well, patients who perform work in mental institutions are now guaranteed at least minimum wage. If they're released from state mental hospitals, they have a right to aftercare and appropriate community residence, meaning housing. And finally, people with mental disorders have a right to receive treatment in the least restrictive facility available, which is why we have not only inpatient facilities, but we have intensive outpatient or IOP and OP or outpatient services. It's also important for us to talk about the rights debate. So there are people who have psychological disorders and they have civil rights that have to be protected at all times. There are clinicians who express concerns that the patient's basic civil rights may be unintentionally deprived of their rights, and in turn, they're denied their rights for recovery or their opportunities for recovery. The clinical field has not always been effective in protecting patients' rights, but while clinicians often disagree, it seems appropriate for patients, their advocates, and outside evaluators to play key roles in decision making and what's going to be the best course of action for the person involved. In what other ways do the clinical and legal fields interact? Well, over the past 25 to 30 years, the paths of mental health and legal professionals have crossed in four key areas, which we're going to be talking about: malpractice suits, professional boundaries, jury consultation, and psychological research of legal topics. So let's first look at malpractice suits. So the number of malpractice suits against therapists has risen sharply in the last decade. And these claims have addressed issues like patient suicide, sexual activity with the patient, failure to obtain informed consent, negligent drug therapy, omission of drug therapy, improper termination of treatment, and wrongful commitment. A malpractice suit or even fear of one can have a major effect on clinical decisions and practice, for better or for worse. When we look at professional boundaries, we find that the legislative and judicial systems have changed the boundaries that separate one clinical profession from another, and they've been given more authority to psychologists and blur the lines between psychiatry and psychology. In 1991, the Department of Defense set up a training program for Army psychologists to gain prescription writing privileges, which was previously a domain for psychiatrists only. There are 5 states and 1 US territory that now grant prescription writing privileges to psychologists who receive special pharmacology training. And I'm actually looking up those states and US territory now because I don't know which ones they are off the top of my head. Which ones are they? So the 5 states where psychologists can prescribe medications are Louisiana, New Mexico, Illinois, Iowa, and Idaho. The US territory, I'm looking for that now. The US territory is Guam. Sorry, I thought I had that written down and I didn't. Now let's look at jury consultation. So over the last 30 years, there are more lawyers who turn to clinicians for advice in conducting trials and also in helping to select juries. They advise lawyers about which jury candidates are likely to favor on their side and which strategies are likely to win jurors during trial. And finally, we have psychological research of legal topics. So psychologists sometimes conduct studies and develop expertise on topics that are important to the criminal justice system. In particular, eyewitness testimony and patterns of criminality are the two that psychologists have geared a lot of their research towards. So eyewitness testimony is extremely influential in criminal cases. And there's been research that shows that eyewitness testimony can be highly unreliable because these events are typically unexpected and fleeting and can cause severe trauma in certain cases. There are lab subjects that can be fooled into misremembering information, and accuracy in identifying perpetrators is influenced by the methods that's used in identification. So what psychologists do is they study this and then use the results of their study or of other studies conducted to dispute what the prosecutors are saying in support of the defense or vice versa. When we look at patterns in criminality, this is the study of criminal behavior patterns and the practice of essentially profiling, which has increased in recent years. It's been the topic of a number of media programs. And in looking at patterns in criminality, it's not as revealing or as influential as the media and the arts would have us believe. Why? Because when we look at patterns of criminality, even though psychology looks at this and the field of sociology and even criminal justice look at this, The behavioral pattern, looking at it from that psychological perspective, is very much based on information that's provided. And if the information that's provided isn't accurate, or if the people who are participating in the study are giving or have some type of bias, giving, for example, the researchers things they think they want to hear, then it's not going to be any accurate information. When we look at the patterns of criminality, what is relayed in the media is not in fact what happens. The information that is gathered through case studies or through information reported through the police and hospital reports and morgue reports, those are the key pieces of information that help us to understand not only about what happened to the victim, but also what subset of people are more likely to engage in certain behaviors. So it comes from a much more scientific perspective than it does a pseudoscience perspective. No matter what, as members of the human service field, we are held to ethical standards, not only by the state, but also by the organization in which we have gotten our license under. So each profession within the mental health field has its own code of conduct. So when we look at the APA, or the American Psychological Association, we find that their code of conduct say that psychologists are permitted to offer advice, but may not conduct fraudulent research, plagiarize the work of others, or publish false data. Psychologists must acknowledge their limitations, and any psychologist who makes evaluations and testifies in legal cases must base their assessments on sufficient information and substantiate their findings appropriately with valid research. Psychologists may not take advantage of clients and students sexually or otherwise, and they must follow the principles of confidentiality with two exceptions. Number one is a therapist in training um, to a supervisor, and number two is Tarasoff's duty to protect. So the Tarasoff case came about when in 1969, there was a university student who was named Tatiana Tarasoff, and there was a perpetrator, Prosenjit, I think is how you say the first name, but Prosenjit Padar, who was an Indian graduate of the University of California, Berkeley, who had met Tarasoff at a dance class on campus. They went on separate dates, and Padar began stalking Tarasoff and underwent emotional crisis, for which he began counseling at the University Medical Center. The therapist knew that Padar was stalking Tarasoff and had mentioned intentions of killing Tarasoff, but the therapist never reported this. So Padar did end up killing Tarasoff, and he stabbed her to death. And this ensued all the way up to the California Supreme Court. And the California Supreme Court ruled that psychotherapists have a duty to protect potential victims if their patients made threats or otherwise behaved as if they presented in a, quote, serious matter of violence to another. So the court determined that the need for the therapist to protect the public was more important than protecting the client-therapist confidentiality. We also need to look at business and economics. So the legislative and judicial systems are not the only social institutions in which mental health professions interact, but they also interact and are influenced by the business and economic fields. So how do we bring mental health services to the workplace? Well, something to note is that studies have shown that work is the leading source of stress for people. The business world has often turned to clinical professionals to help prevent and correct the problems that can occur in the workplace. Two means of providing mental health care in the workplace are EAP, or Employee Assistance Programs, and problem-solving seminars. Employee Assistance Programs, or EAPs, offer mental health services by a place of business, and they're either run by a mental health professional who work directly for the company or an outside agency. Most today are outside agencies. Stress reduction and problem-solving seminars are workshops or group sessions that occur at work in which mental health professionals teach employees techniques for coping and problem-solving and handling stress. both in the workplace and when work affects them outside of work. When we look at the economics of mental health, economic decisions by the government may influence the clinical care of people with psychological disorders. An example of this are financial concerns, which were the primary consideration for the deinstitutionalization movement. There were a lot of people who were placed in institutions that were not receiving care, or funds were being improperly mismanaged. So in addition to advocating for patients' rights, deinstitutionalization then created the breaking up of these institutions and allowing individuals to have more rights and responsibilities over their care and more advocacy for themselves. Something to note, though, is that although government funding has risen for people with psychological disorders over the past 5 decades since deinstitutionalization, it's still not enough. The large economic role of private insurance companies has had a significant effect on the way clinicians go about doing their work. Unfortunately, managed care programs and peer-reviewed systems that have been implemented are often criticized by many mental health professionals because it restricts the mental health professional's ability to practice in a meaningful way, or in a way that's in protecting the rights of the client, and they're also not receiving pay for the work that they complete, which is why a number of seasoned clinicians no longer work for an agency or organization and often go into private practice so they can make more money. The reimbursements from Medicare, Medicaid, and insurance companies are often far lower than the cost per hour that a therapist should or could earn. We also need to look at technology in mental health today, especially at the time of this recording, which is in spring of 2021. Technology in mental health has been huge over the past year since, or 14 months since the pandemic has occurred. So technology has begun to have significant effects, both positive and negative, on the mental health field. So we can look at how technology like the internet, cell phones, video games, and social networking have positively and negatively impacted the mental health field. And we're going to be talking more about this during our time together. There are also new triggers and vehicles for psychopathology. Our digital world provides new triggers and vehicles for the expression of abnormal behavior. So, for example, those who grapple with impulse control problems and or paraphilias can now find places where they can network online or gather together online, and even in a way that's not illegal, so that they can support each other and they can engage in these, and talk about their their issues or concerns or what they like or don't like. There's also this notion of internet use disorder. And internet use disorder is not technically it's not a DSM-5 treatment, but this is where we are looking at someone who is, playing video games on the internet excessively. They're compulsively shopping online. They can't physically stop checking Facebook and that social media, and utilizing their smartphones are interfering with their daily life, with their relationships, and with work and with school. So when we are thinking about this, it's definitely something that's prevalent, and it's something that is negatively impacting people. Some clinicians worry that things like social networking can contribute to psychological dysfunctioning in certain cases, especially when this impacts negatively the ability for people to have healthy views of themselves or have healthy self-evaluations. There's also new forms of psychopathology. So today's technology is also helping to produce new psychological disorders. Just talked about internet use disorder. And similarly, the internet has brought a new kind of exhibitionist feature where they're perpetuating abnormal behavior. So for example, you can go online and Google and you can find videos where people are posting themselves cutting. Telemental health, especially in the last 14 months, has been huge, and it's growing by leaps and bounds. There are now HIPAA compliant programs that can be utilized in order to help people receive treatment by using their phones or their computer with a camera, or by phone. if they want to talk and they don't have access to a camera. So when we think about this, something to note is that the actions of clinical researchers and practitioners are not only influenced, are not only, so they're not only influenced by other institutions, but they're closely tied to personal needs and goals. So you didn't come into this profession with, without ever having an incident or something occur to you, that wouldn't lead you to this field. You didn't wake up one day and say, you know what, I want to become a psychologist or I want to become a counselor and have never had a problem. As many as 84% of therapists have reported being in therapy at least one time in their life. The main problems are emotional problems, depression, and anxiety. And it's not clear why many therapists report having psychological problems before coming into their work as a therapist or after they become a therapist. But some theories are the biased entry into the field itself, stress with their job, and by going through their educational program and training, they have increased awareness of negative feelings. When we look at the science and profession of abnormal psychology, we seek to understand, predict, and change abnormal functioning, but we must not lose sight of the fact that mental health researchers and clinicians are also human beings, and they live within a society of human beings, and they work to serve human beings. So understanding, predicting, and changing abnormal functioning may impact themselves, it may impact their loved ones, it may impact their clients, their local community, and even the larger community. Within a larger system, something to note was that at one time, clinical researchers and professionals conducted their work largely in isolation, but today they have many ties to legislative, judicial, economic, and even other social research platforms and technology. The clinical field has reached a high level or a much higher level of respect and acceptance in our society, but there's still stigmas. And those stigmas are slowly starting to go away, but they still exist. The effects of this larger system on an individual's psychological needs can be positive or negative, like whether the family impact is positive or negative, or whether the disorder or illness that they're dealing with is socially stigmatized. If that's in fact the case, just understand that the forces are not just going to be based on that individual, but it's also going to be based on the forces that are impacting the individual themselves and their functioning. I hope that this was helpful. As always, if you have any questions, comments, or concerns, please feel free to reach out to me via email. Also, don't forget, in the description box below is this week's extra credit question. All you need to do is answer the question in the comment section below, take a screenshot, and upload it to Canvas by Sunday at 11:59 p.m. in order to receive up to 1 point added to your final grade. Until next time, I hope you have a great one and be well.